I can't advertise my work as Native American art, which it is.
This law is anti-competitive, and the purpose of it and the effect of it is to discriminate against Native American art from other states.
It flips on its head the whole concept of truth in advertising.
Peggy Fontenot began her native art career decades ago, working in beading, silver jewelry, and photography.
When I started photographing, I thought that people ruined my photographs. And then I realized that the people were the stories and that they made the photograph.
She's a part of the Patawomeck tribe and has built a career that has taken her everywhere.
I travel all over the country selling my work. I show at different museum shows. For 4 years, I did the jewelry for the Kathy Ireland Sports Illustrated swimsuit calendars. I felt it was a real honor to be included.
Everything was going great with her career. That was until 2016 when a new law passed in Oklahoma and changed her entire world.
Members, this is House Bill 2261. It provides safeguards for Native American artists and for the collectors of Native Indian art.
That's State Representative Chuck Hoskin, the writer of the bill. The new law made it so only people from federally recognized tribes could call themselves Native artists.
Peggy belongs to a state-recognized tribe, and so thanks to this new Oklahoma law, she can no longer market her art as Native American in Oklahoma.
That's Fontenot's attorney, Anastasia Bowden, with the Pacific Legal Foundation. She's representing Fontenot in a lawsuit against the state, saying the new law violates Fontenot's free speech rights.
To call every state-recognized tribe fake and illegitimate is just broad sweeping and wrong.
She could also face fines or imprisonment if she describes her work as she always has.
I can still sell my work in Oklahoma, but I can't advertise it as Native American made, which it is.
That's actually the whole point of the law, is to narrow the universe of people who can describe particular art as American Indian art.
Clark Neely is a vice president of the libertarian think tank the Cato Institute and spent 17 years as an attorney at the public interest law firm the Institute for Justice.
Very clearly, some group of people want to prevent other people from using that terminology, presumably because it has some value in the marketplace.
Oklahoma is central to Native American artists. They put on some of the biggest Native American art shows in the country. Each year, Peggy goes to the Red Earth Festival, where thousands of people come to either show their art or to see Native American art. Peggy will miss out on earning a living in Oklahoma. She makes her money by going to these art shows. She's really upset because she thinks that this is free speech and she's not able to truthfully call herself what she is.
It completely undercuts and flips on its head the whole concept of truth in advertising.
My beadwork and my work isn't going to have the same importance if it's not being marketed as what it is, which is Native American.
Hoskin declined our interview request, but he said in a statement, "We have seen people time and time again falsely claim heritage in order to market themselves as a Native artist. And this closes a loophole in the federal act here in Oklahoma protecting Oklahoma Indian artists." Rebecca Tushnett is a Harvard law professor who studies truth in advertising law. She says it may have been poorly crafted, but the Oklahoma law was well-intentioned.
I think they were interested in the same basic question as the federal government was, which is how can people sell this stuff and how can they be truthful about what it is?
Tushnett says that sellers misrepresenting their products is a significant problem in the native art world, and that a federal law that defines a native artist more broadly has done some good.
The reason at least the federal law was enacted was a fair amount of fraud on the market, which was doing harm to legitimate artisans.
For example, 5 people were indicted in July 2017 after being accused of importing and selling fake Native American jewelry from the Philippines.
The 5 suspects are accused of violating the Indian Arts and Crafts Act.
But Bowden says the purpose of the Oklahoma law is to restrict competition.
This law is anti-competitive, and the purpose of it and the effect of it is to discriminate against Native American art from other states.
They want to sell their art, and if they can limit the number of people who can compete with them in that space, then presumably you limit competition, you expect prices to go up. It's simple economics.
Federally recognized tribes are a big constituency in Oklahoma. And Hoskin isn't just the author of the bill, he's also served as the chief of staff for the Cherokee Nation.
And of course, the Cherokees are a federally recognized tribe, and certainly would have an interest in putting a law on the books that says that only federally recognized tribes can call themselves Native American.
The 5 big federally recognized tribes did officially come out in support of the state against Fontenot.
For me to come out by myself and challenge these tribes, I definitely feel that I'm up against the world, if you will.
Businesses or even individuals who are facing competition have essentially two ways to come out ahead. One is to up their own game, or you can go to the government and try to sandbag your competitors. I've seen this kind of thing over and over again, whether it's organic food or interior designers or catfish. It is now the case that of the 2,500 different species of catfish in the world, you can only sell in America one particular fish as catfish, and that's the North American channel catfish. Why? Because that's the kind that we raise here in America, and the people who raise that fish went and got a law passed that says that's the only kind you can call a catfish.
Fontenot's lawyers were able to stop the enforcement of the law temporarily so that she and artists like her could continue to show their art in the state. HB 2261 is still on the books though, so it isn't a permanent solution yet.
If we're not successful and this law stands and it goes to other states, at the end of the day, I'm still Indian.